Hi, my name is Ewan McGaughey, and we are here to talk today about enterprise law, what enterprise law is, and why this law of business, of regulation, and of public services matters so much. So this is just an introductory talk before we have much more to come on history and theory, the general law of enterprise, and the really important stuff, which is sector-specific regulation. So this concept of enterprise law is rooted in the idea that we need to understand our economic constitution. This is taken from a speech by the American president in the 1930s and 40s, Franklin Delano Roosevelt. As I see it, he said, the task of government in its relation to business is to assist the development of an economic declaration of rights, an economic constitutional order. And that goes to the notion that we all understand our political constitution, we understand the separation of powers between the judiciary, the legislature, and the executive. But when it comes to human rights that aren't just civil and political, but are economic and social, like the right to work and fair wages, social security, but also education, health, the right to clean environment, the right to the benefits of science. All these things describe what goes on in our economic constitution, but until recently, we haven't had a coherent way of understanding it. Certainly not taught in law schools in Britain or Europe, and not until recently either in the United States, the Commonwealth, or all the rest of the world. And so that's what enterprise law is really about. This introductory talk is just going to go through what enterprise law is, why enterprise law matters for reality, and why we need to do enterprise law, or as some of my American colleagues are calling the topic, networks, platforms, and utilities. So let's get into the first question. What is enterprise law? And the way that I define it in my book on enterprise law, that's it there, second edition coming soon, is that enterprise law is the regulation of the finance, governance, and rights in economic life. So the concept covers all enterprises, whether they are nationalized or privatized, or whether they are locally, transnationally, cooperatively, or really however owned. It doesn't matter what sort of silo between public or private law the enterprise falls into. Enterprise law seeks to show things like these, how our major corporations function and how they really behave, including under sector-specific public laws. For instance, in education, like universities and healthcare, the NHS, banks, which are private companies, at least the retail investment banks, merchant banks are, but how they operate with the enormous body of regulation and also alongside the central bank, like the Bank of England, the Federal Reserve, the European Central Bank. How energy corporations work, water corporations, transport, big tech, again, whether they are public or private, regulated well or not very well. And this sector-specific approach matches stock market classifications, it matches human rights, particularly social and economic rights, and it matches how government departments are usually organized. And this sector-specific approach is so important because it helps us solve real-world problems like the growth in inequality and problems with the welfare state, about improving public health, stopping ill health, tackling climate damage. That's the energy industry, the transport industry, agriculture, housing and construction. Addressing problems that are growing with big tech and democracy, like the spread of fake news and the use of algorithms manipulated by the owners of big tech platforms in a way that could undermine democracy. And also, when we look at the military, we see how enterprise law can help us understand the problems and the economic causes of war. Enterprise law is based on economic reality, not legal abstraction, and it's worth going a little bit backwards into the theory about where this concept of enterprise law originated. And these are three authors from Britain, Germany, and America who start talking about enterprise law in a sort of systematic way and begin to put down the foundations of how we should understand enterprise law. So the first one is A.A. Burley, who was one of the speechwriters for Franklin Delano Roosevelt in the 1930s. And that quote that I gave you from Roosevelt at the start was actually from a speech that Burley, who was a corporate finance lawyer, wrote for him. So Burley argued in a 1947 article called The Theory of the Enterprise Entity that corporations take their being from the reality of the underlying enterprise. So a corporation is a legal entity, but usually it operates not as a single corporation, but as a constellation controlled by a central holding. You usually have an enterprise group. So if you think about Alphabet, which runs Google, there is a central corporate holding, Alphabet Inc., but it will have dozens, maybe hundreds of subsidiaries all around the world in jurisdictions, not just jurisdictions like the United States, which parcel up and deliver the services and goods that an entity like Alphabet runs. But so it's not important not just to understand the corporation, but the enterprise as a whole, usually a constellation of corporations. So the economic reality, says Burley, is more important to understand than just the legal form. And so if you are a corporate lawyer, as I was trained to be, then we are very good at understanding individual entities, but taking back and looking at the economic context and the broader body of regulation in which they operate is very important. Thomas Reiser from Germany writes in a 1988 article called The Theory of Enterprise Law in the Federal Republic of Germany. And he says that the governance of an enterprise includes the exercise of power and therefore requires legal mechanisms for its control. The social purpose of constitutional rights, says Reiser, and the principle of the social state are of utmost importance in enterprise law. And so what Reiser is talking about here is often very unfamiliar to people who just practice in corporate law or competition law, that there are really important social, political dimensions to what corporations do. And of course, we all know this, but it's not always the case that there's an integrated understanding of public law and the private aspects of corporate regulation, competition law, and so forth. And so, bringing in constitutional values into the understanding of the economy is key, says Reiser, and of utmost importance in the understanding of enterprise law. And Simon Deacon in the UK in 2012, in an article called The Corporation as Commons, says that to understand the business enterprise or firm behavior, the idea of, or the economic idea of the firm is pretty much the same thing as the word enterprise. Company law or corporate law just explains a fraction of reality. So really we have to bring in insolvency law, employment law, tort, and arguably competition and tax to get the full picture. Ironically, we cannot understand how corporations really behave without this broader body of law. We can't understand corporations from corporate law alone, because on the contrary, the reality is that a corporation is simply expressing what an enterprise does. And so that's why this broader concept of enterprise law, which integrates more legal subjects, is so vital. So that was the theory, and slowly in the law, the enterprise has become more and more important, particularly from the second half of the 20th century. So the use of enterprise law, the use of the enterprise concept, I should say, first really started in the law in 1961 with amendments to the Fair Labor Standards Act of 1938 in America, Section 203R. Says that an enterprise is defined as activities undertaken for a common business purpose by one or more corporate or other organizational units. And as you probably know, what the Fair Labor Standards Act in America does is it creates the minimum wage in America, also creates limits to working time. So you get overtime if you work more than 40 hours a week. And one of the purposes behind the amendments in 1961 was to make sure that things like the minimum wage were made effective against everyone who undertakes employer functions. So the net of regulation was cast wider than just who do you have a contract of employment with, who is the corporate unit that usually your employer is organized as, but there's this idea that the enterprise, which has responsibility for social rights, is bigger than the corporation. It is one or more corporate or other organizational units. So there's a functional test behind the definition of an enterprise, not just a test based on legal forms. And if we look at antitrust law or competition law, this is known in Britain and Europe, tort law, corporate accounting, tax, all of these areas of law slowly started to focus on the enterprise. Sometimes it's called different things. So in antitrust or competition law, we look at the undertaking rather than just the corporation. Tort law talks about enterprise risk. Corporate accounting and tax often looks at corporate groups. But all are doing the same thing, even if different words are being used, which is focusing attention on the real economic unit rather than just legal units, again, in order to make rights effective, like the right to fair competition, the right to compensation in tort, the right of the public to ensure that corporations fully pay their taxes. And then in public regulation, we can look at examples like the General Data Protection Regulation in the European Union. And this defines an enterprise in Article 418 as a natural or legal person engaged in an economic activity, irrespective of its legal form. So you see the theme that is coming up again and again, which is that the concept of enterprise is about the underlying economic functions, not just the legal form and the legal unit, because we want to make sure through the GDPR that our right to data privacy is effective, whoever is holding our data. And then you've got this concept of enterprise used repeatedly in the UK in lots and lots of acts which refer to, well, use the word enterprise, like the UK Enterprise Act 2002 or 2016. They never actually define what an enterprise is, but it covers, or these acts cover everything from competition to insolvency to rules on education and so on and so forth. This concept of enterprise is clearly being used in a way that is bigger than just traditional corporate law or other traditional private law subjects. Okay, so bottom line is that the enterprise concept is used to make rights effective, to ensure that they're not evaded by focusing on the real economic entity, not legal form. And it can be used to describe all components of our economy. So how enterprise law can look is like this. We can see, a bit like in contract law, how we understand there's a general law of contract and there's specific contracts like employment and agency and insurance contracts and so on. We can see that there's, like the pyramid in the middle of this diagram, a general law of enterprise, which we can see is composed of company law that regulates the people at the top, the board of directors and the shareholders. That's what company law is most usually focused upon. Then also, who contributes the money, who invests the money into companies. Well, it's usually a large group of beneficiaries, saving in pension funds, insurance funds, mutual funds, and there's a larger body of law on insurance or the Pensions Act 2004 in the UK, which regulates the rights of the ultimate capital investor. So one edge of the pyramid in the general law of enterprise is about company law and investment law. We've also got a whole body of regulation that manages the interests of the contributor of debt capital, not equity capital, but debt capital and the interests of the creditors. So the Insolvency Act in the UK is the most important for that. And then in the orange, we've got the investment of labour into a company. So the Employment Rights Act 1996 is a primary statute in the UK for protecting the interests of workers, or the Trade Union and Labour Relations Act 1992 is about mitigating or mediating the rights of trade unions vis-a-vis the employer and workers who are members of trade unions. And then the fourth edge of the pyramid is, in this diagram, the interests of consumers. So the Competition Act makes sure that consumers have or can buy and sell goods and services in an environment where fair competition prevails rather than one rigged by monopolies or cartels. You've also got the Consumer Rights Act 2015. And we find pretty much the same thing in every system of law around the world. We have rules on equity capital, debt capital, labour and consumers. And we can see this as the general law of enterprise, where more or less, if markets work, if competition in particular works, then you don't really need extra specific laws. Okay, but then the important notion is that very often this general law of enterprise is not enough because competition doesn't work, or there is recognised to be some extra socio-economic or political need for specific regulation. So we have special rules on the education sector. We don't just leave it to free competition in the market. There's the Education Act 2002, there's a Higher Education and Research Act 2017, we've got the NHS Act 2006 for healthcare, we've got the Banking Act 2009 and the Bank of England Act of 1946 to regulate the banking sector when they go, hopefully they don't go bust, and to make sure that the central bank exercises prudential oversight. We've got rules like the Petroleum Act for natural resources, the Electricity Act 1989, the Water Industry Act 1991, the Agriculture Act 2020, the dozens of housing laws like Housing Act 1980 or 88, Railway Regulation, Communications Act 2003, the rules that set up the BBC and a Royal Charter and regulate the media industry. Marketplaces, really interesting. Covent Garden Act of 1961, an increasing volume of sector-specific law that applies to big tech marketplaces, or rules like the Armed Forces Act 2006 for the military. So you have this enormous body, and we could go on with more specific sectors. We have this enormous body of regulation which applies on top or adjusts the general laws of enterprise. That's what we can call specific enterprise law. And so if you really want to understand how banking corporations, electricity or energy firms or transport companies operate in the real world, we need to bring in this other regulation to get the full picture. But then you might go, well, how can we make sense when we've got this disparate set of rules? How can you make sense of it, of any? Because there is admittedly a large body of regulation that we're going to look at throughout this course. And I think that the answer is that if we take a functional approach to the way that the law works, we look at its human meaning and what role the law really performs rather than being wedded to legal form, then we can have a coherent intellectual grammar that cuts across all kinds of enterprises, whatever their field. So I propose that there are three main functions that enterprises fulfill: a finance, a governance, and a rights function. And through this, we can understand everything. So the finance function is that enterprises accumulate resources. They gather equity capital, debt capital, labour. They take the benefits of people's custom, or the consideration that service users provide. And so you have a body of rules in each sector which shape the way in which the financing of an enterprise is achieved. Now, general law is, at least in theory, quite easy. You have people providing capital and labour. into a company. But then in many, many specific sectors of enterprise, we also see that enterprises are funded, in effect, even without a cash transfer necessarily, in other ways. For instance, you might have a company that pollutes a lot, and the pollution is not controlled or precariously controlled. And this, in effect, gives a regulatory subsidy. More about that in just a minute. Second, you have the governance function of enterprises. So there are rules in all these enterprises which mediate who controls power and who coordinates production in the enterprise. So that might be the distribution of power between the board and management and employees, or other investors, who has the right to vote for who's running the organization, the powers of regulators, directors' duties, and so on. And then you have a rights function, how are rights distributed from the firm, how resources are distributed, such as income, dividends, and goods and services for service users. Okay, so this provides a pattern for all enterprises, whether privatized, cooperatives, mutuals, or nationalized, from everything from health to big tech media. I think that this way of thinking about things maps nicely onto an old book by Hirschman called Exit, Voice, and Loyalty. We've got the language of markets, and that's the finance function, the language of voice. We extend that idea to governance more broadly, and loyalty, which is a complicated concept for Hirschman, but we can expand this to, what are the enforceable rights that people have against the enterprise when they are service users. We can break down this taxonomy a little bit more. So, and this is something that I try to follow throughout the analysis of enterprise law. So first of all, with the finance function, we all understand equity and debt in corporate law, but then there are many additional ways in which enterprises are in fact financed. So you might have public investment and public ownership of enterprise. So the NHS is an easy example. Government owns and runs the hospitals in order to make sure that public healthcare is as good as it can be. In almost every country, the public sector owns the central bank. So this is a public mechanism of finance on top of simply raising private finance from equity and debt. And then you also have state aid, very well understood by competition lawyers, of course, so government can give state aid to companies either with cash transfer or through regulation, guarantees against insolvency, for instance. Stepping back more broadly, and now probably outside the zone of state aid, but into the zone of structural answers in competition law, you might have an enterprise which exploits a natural monopoly that isn't properly controlled, or they exploit an unequal bargaining position, which acts as a regulatory subsidy. So if the law doesn't control the natural monopoly and service users are paying much too high prices, then this is in effect a subsidy. And as I mentioned before, you could have the concept of not paying for externalities, external costs that you put on other people, which makes your production cost cheaper as an enterprise, like if I pollute but I don't pay. And environmental law, of course, is about that, but seeing it through the lens of enterprise allows us to tackle pollution at its source. And then we've got governance. So in company law, standard rules on who's on the board, shareholder appointments, also appointments by workers, service users, as we'll see, quite common also in governance in the public and regulated sector. We also have governance rules like these, which are often outside of a standard corporate law text, like licensing by a regulator. Are there conditions for a water company or an electricity company or a train company to operate? What controls are there on their fees or their prices or their profits and the standards of service? There might be structural separation rules that a regulator puts in place, like investment banks and retail banks should not operate together. There might be specific duties in law beyond the simple catalogue of directors' duties that we usually see in company law, specific duties to service users or the public. And there might be special insolvency rules. So, if a water company goes bust, we don't want to let the taps run dry. So we don't just allow creditors in the normal way to take over the management of the company, to extract the value to get their debts repaid because there's a public interest at stake. And then there's rights of service users. So standard law of contract in a competitive market will govern the rights of service users. What are the terms of the contract? We have a baseline of consumer rights, but not much other than that. However, in enterprise law, we see much, much more than that. You might have a specific right to a service. The service might be free at the point of use, as in primary school, or it might be guaranteed to go to everyone, universal service regardless of where you are, like is common for the post office and the mail, or right to equal treatment. You might have a right to get goods and services at fair prices with a price cap. You might have a right to fair standards of services. And there might be special rules on procedures and complaints if the standard of service is no good. Okay, so that's the taxonomy that I adopt, finance, governance and rights. And I think it's worth seeing that this is very, very similar to what other people are thinking around the world. My colleagues in America who've written a book called Networks, Platforms and Utilities. And there's a second edition coming soon. Ganesh Sitaraman, Morgan Ricks, Shelley Welton and Lev Menand have what they call the regulatory toolkit, which describes common methods in networks, platforms, and utilities law, as they call it, or enterprise law, as we call it in Britain and Europe. They have this regulatory toolkit, which is pretty much the same thing. So there's price and profit rules, access and service rules, industry structure rules, they say, and that overlaps in a great deal with the things I've just described on the last slide, but with a few exceptions. And so networks, platforms, and utilities usually covers these other things that I've listed on the right-hand side, like state aid, natural monopoly, externalities, and so forth. But the regulatory toolkit is, of course, something that can expand and evolve as a concept. And most importantly, we find similar mechanisms of regulation in many, many systems of law. Okay, so when we look across the economy, and this is really why it starts to matter for reality. There we go, missed a slide. Why does enterprise law matter for reality? First of all, we can look at it from the perspective of how it benefits existing legal practice and legal academy. So by looking at enterprise law, competition lawyers gain a common grammar of structural, not just behavioural remedies for abuse of a dominant position by a monopoly or the abuse of data or power. We understand conditions when markets work or not through an enterprise lens better. Public lawyers and human rights lawyers gain an understanding of the details of legislation that realizes social, economic, and other human rights, common structures for administrative power in a regulatory state, and the full economic constitution alongside the political constitution. Human rights norms in particular often set, big high-level goals, but they're like the destination of where to go, and enterprise law gives us the map. Labour lawyers gain a better understanding of the nature of each employer, the constitution of the employer, how this affects rights of work, and the drivers of evasion of rights. And if you're a business or economic historian, enterprise law helps with the legal scaffolding and how the basis for the economy and the economic fundamentals develop. And when we look at stock market classifications, this is from, admittedly, a few years ago now, but the FTSE 100, and these are the top 25 companies on the Financial Times Stock Exchange listings, we can see that most big companies, even though we might start off by understanding them through corporate law, most big companies are in sector-specific regulated fields. So if we look at the top couple here, Royal Dutch Shell, and HSBC. We have an oil company that is specifically regulated by the Petroleum Act 1998 if it's drilling for oil still around the UK. Or we've got HSBC, an enormous global bank which is subject to the Banking Act 2009, the prudential oversight of the Bank of England. They're specifically regulated. Go down the list, you see, for instance, at number 13, Vodafone, subject to the Wireless Telegraphy Act, and need to get a license, and the Communications Act 2003, which sets standards for communications that are set by Ofcom. So the vast majority of big companies are subject to sector-specific regulation. So if we want to understand how they really operate, then we need to understand enterprise law. And enterprise law accounts for most of the economy if we measure that by GDP. So this chart shows UK GDP by sector in 2021. And if we go clockwise around, I've put the sectors which are subject to specific regulation: real estate, finance, IT and comms, health, construction, education, and so on. These are the specifically regulated sectors. And then after they finish, manufacturing, wholesale, scientific and technical, admin support, these are non-specific sectors. These are regulated by the general law of enterprise broadly. And, this is a sort of blunt classification, but nevertheless, I think it goes to illustrate that a large body of our economy is subject to specific enterprise regulation, and that means it's important to understand. And if you are a human rights lawyer, we understand that social and economic rights are often not very well delivered. As I mentioned before, you have these high-level goals of the right to education, health, the right to work, the right to housing, an adequate standard of living. And all of these things are determined in practice by a whole body of detailed rules on education for schools, universities, health policy, banking is really important for human rights. What's the level of employment? What are the level of prices, which are influenced by interest rate policies of the central bank? Food and water. Your right to food and water is mediated through agricultural policy and subsidies, the policies on control of pollution by water companies, or whether your water companies are publicly owned or privately owned. There's a right to share in scientific advancements and its benefits. This is closely connected to the energy industry, transport, communications. We have the right to privacy and freedom of expression, and this is intimately connected with the media. And we have the right to security and liberty, which, of course, you can't fully understand with seeing how the military operates. So human rights are a destination. They're the high-level goals of where we want to go. Enterprise law gives us a map to understand how to get there. Enterprise law in a sector-specific manner, organised in a sector-specific manner, matches what governments really do and how governments organise themselves as well, whether it's the UK, the EU, the United Nations, or really any government around the world. You don't often find a department of private law and a department of public law or a department of property, obligations and persons. What you find are departments like these: the Department of Education, Health, the Treasury, the Department of Energy and Net Zero, agriculture, housing, transport, and so on. So you get the point that, if governments are organising the way that they are fulfilling their legal mandates through this manner, then it can be very helpful to have a legal education which is grounded in the same reality and the same understanding as the real world is too. And also, if we look at how law firms organise themselves, here's one law firm, a big global law firm called Hogan Lovells, which I've chosen at random. It could have been any one of the white shoe firms, Magic Circle firms in the city, or really anywhere in the world. Law firm practices are increasingly organised along sector-specific lines like this. That they'll have practice areas for education, health, financial institutions, real estate, sport, tech, and so on. And of course, you have lawyers that have a classical legal education where they've done corporate law, they've done administrative law. But if once they get into the real world, specializing in subject areas is very important. And so legal education, I think, needs to match the reality that people operate in. Here's another example from another big law firm called Clifford Chance. Okay, so the final thing that I want to address is, do we really need an enterprise law, or the law of networks, platforms and utilities, as my colleagues in America are calling it? And there is a very prominent set of arguments that says no, we do not need enterprise law at all. And it starts with the idea that the classical way of organizing the legal curriculum goes back to the Romans, and we should stick with doing what we did 2,000 years ago, long before the Industrial Revolution. So Roman law, as everyone knows, and we see this in law schools all the time, was organized between public law and private law as a sort of binary division that starts off the organization of the law. So public law includes constitutional law, judiciary, executive, legislature, and the relations between these bodies. Administrative law, which is mostly focused on judicial review and looking at a whole range of public bodies and the extent to which they can be controlled by the judiciary to be accountable under law. And criminal law. So those are the sort of main elements of public law. And then you've got private law. You have the rules of the laws of persons, which includes corporations. And you have the laws of property, rights in rem, so land, rights in personam, so sale of goods, or rather property over goods. And then you have the law of obligations, including contracts, torts, and unjust enrichment. And this classical way of organizing the legal curriculum runs very, very deeply in a lot of people's psyches. So Frank Easterbrook argued in 1996 in an article provocatively titled The Law of the Horse and the Law of Cyberspace, that we should only study general rules like property, torts, and commercial transactions, which illuminate the entire law, he says, and not study courses suited to dilettantes like transport law, the law of the horse, or internet law. And so what Easterbrook was arguing was, well, we could look at all of the laws about a horse, so you sell the horse, there's a contract, the horse gets injured, maybe there's a tort, somebody nicks your horse, well, there's a bit of criminal law. But the law of the horse does not give you a proper legal education because you don't have an understanding more broadly about what might happen to a pig or what might happen to a cow. If you're just focused on the horse, then you don't have a subject that illuminates the entire law, like he says, property, torts, commercial transactions. And in another article, he says that we should keep corporate law for sure away from, some form of public control. So he was arguing for what you might term a conceptual understanding of the law, in his view, rather than a contextual understanding. And when it came to sort of other fields of economic regulation, colleagues of Frank Easterbrook's at the University of Chicago said that economic regulation should be done or understood in a very specific way. So each field should serve a single goal. Corporate law's main goal was to pursue shareholder profit. Bankruptcy or insolvency law should be all about creditor wealth maximization. Baird and Jackson and Friedman arguing this respectively. Antitrust law or competition law is only about consumer welfare. Labor law, if it exists at all, argues Friedman, is really about the welfare of the individual employer. Don't want to have too much about unions because unions, according to Friedman, were bad for workers. And any notion of the public interest is absent. Regulators, by the way, argue George Stigler, another colleague of theirs, are usually captured by the entities that they want to regulate. So most economic regulation should be understood through the lens of single goals. And there's really no room for study of, for instance, publicly owned corporations. There's no room to integrate all stakeholder interests to pursue the public good. We should keep public regulation out of the way. On the contrary, I think that we can make a very good case about why a sector-specific understanding, as we are doing in enterprise law and we're going to do, is more preferable than the Chicago School way of understanding the economy and the limitations that it has. There's at least four problems of this idea that we shouldn't study the so-called law of the horse, and that we should limit ourselves to the traditional Roman law way of organizing a legal curriculum. First of all, it's simply swimming against the tide to not study sector-specific enterprise regulation because, as I said, it matches how governments really work, how stock exchanges organize, how law firms actually classify their departments. And so if the real world is doing this, and by the way, there's an enormous growing body of law which does do specific regulation, then the legal academy should do that. So enterprise law does really, truly illuminate the entire law, much more than the way that Frank Easterbrook and his colleagues would like us to have it done. And pretending that specific rules for corporations don't exist is just a losing game. Frank Easterbrook and his colleagues might not like specific regulation, but it is there. It's an incredibly important part of our lives. So simply ignoring it and not studying it, pretending it doesn't exist, is a losing battle, or a battle, on the contrary, that is already completely lost. Thirdly, understanding specific rules help us understand the real world and solve real world problems. So growing inequality and the problems of the welfare state are understood through understanding housing and health and education law, amongst other things. Solving or preventing climate damage and war. These are things that we can do when we address the specifics of sectors, rather than simply sort of clamping down everything on pollution and environmental law. We can understand the generation of pollution at its source. Now, of course, a lot of people might not want to solve problems like growing inequality. They might want to ignore climate change. But for those of us who do want to solve real-world problems, it's important to do enterprise law. And finally, there is a coherent taxonomy of finance, governance, and rights that can help us understand across different sectors how the world really operates, including the law of the horse, the law of transport. And because we have a functional taxonomy, because we can apply a functional taxonomy, we aren't just looking at a course for dilettantes, dipping in and out of this and that. On the contrary, it's incredibly important to have a functional understanding that cuts across lots of different areas to organize those areas and make them better. And that is a framework that the Chicago School completely lacks. And I think to get to the real heart of the problem with the Easterbrook argument, or the arguments of Friedman, that we should just sort of look at one purpose and we of each area of law, we should ignore the public dimension. The core problem is that the public-private divide is in fact a context-specific, or in their terminology, law of the horse way of organizing things. Because what the private does is it focuses on the market, and public is just everything else. And so for people from the Chicago School who are obsessed with free markets, despite all the evidence of the social and economic harm that happens when markets don't have rules, despite being obsessed with private, it is the case that most markets, most operation of the economy is integrated with public regulation. So arbitrarily taking out the law of persons, property and obligations, the law of the market, and separating that from public regulation means that we are deluding ourselves about how the real world really works. So actually they are studying contextual subjects as well. They're just doing it in a disorganized and ideologically driven manner. Because in reality, everything is integrated as a social system, as a social whole, and the public-private divide is inherently non-existent. So to conclude, enterprise law is useful to understand the vast majority of neglected rules that matter in our lives. Secondly, it matches how stock markets are classified, how governments and law firms are run, and legal education should match reality. And thirdly, what we look at in this course in enterprise law is how the economy actually operates, and using a functional approach, we can understand the entire economic constitution in all its complexity, all its wonder, and all of the fascinating things that are to follow.